Monday morning live.
1 second, it is loading. I will let you know when it's live. We are live.
Okay, good morning, everyone.
Morning.
And
Morning, sir.
welcome to the Workers' Comp Oversight Committee. I'm Senator Kathy Klossmeyer, and I'm glad you all are here to start Monday off for the next week with a great meeting. And I'm going to let Delegate Valderrama say a few words.
Good morning, everyone, and thank you for joining us this morning. It's been a while since we've convened, and unfortunately still not in person. Hopefully this will change next year. God willing, both Kathy and I are both here. Knock on wood. Having said that, we just have a few bills to discuss with the committee, and everyone will find out what the status is on each of these pieces of legislation as we begin. So I think Kathy wanted everyone to introduce themselves really quickly.
Yes. Okay.
Yeah.
Let's go. I'm just going to about the pictures. Nathan.
Nathan McCurdy, counsel to Senate Finance Committee and the Oversight Committee.
Erica.
Good morning, Erica White, counsel to the House Economic Matters Committee and to this Joint Oversight Committee.
Carmine.
Good morning, Carmine D'Alessandro. I'm Chief Legal Officer at Chesapeake. I also serve as President of the Injured Workers Insurance Fund.
Gary.
Gary Pushkin, I'm an orthopedic surgeon, and I'm representative of MedChi, the State Medical Society.
Michael.
Mike Como, citizen member from Harford County.
Rudy.
Good morning, everyone. Rudy
Not
Rose.
driving.
I am parked in front of the commission hearing site in Cambridge, and I have a hearing after this, so the car will not move, period. Although the commissioner may come out and get me. I'm here gladly to be with everyone on behalf of the employers and insurers, defense industry, and workers' compensation. Thank you.
Mary Ann.
You're muted.
Good morning. I'm Mary Ann Rushling, and I'm a representative of the small businesses in Maryland.
Thank you. Ron.
Ron Travers, I'm Division Chief, Baltimore City Workers' Compensation Division, Municipal Representative.
David.
David Benedict, State Relations Executive with NCCI. We are the rating organization for workers' comp for the state of Maryland.
Carl.
You're muted, Carl.
Everybody's wish. Carl, I'm chair of the Maryland Workers' Compensation Commission, sitting in for Commissioner Quinn as an ex officio member.
Okay, well, we're glad you're here, though, if we have any special questions. Jim.
Jim Lanier on behalf of the Maryland Association for Justice, representing claimants.
Mr. McAllister.
Same thing as Jim Lanier, Maryland Association for Justice.
And Tom.
Tom Phelan with Chesapeake Employers Insurance Company. We're representing the industry.
Okay.
Tom, don't you want to show your face?
Oh, wait a minute. We have two other.
We have Senator Feldman with us.
Senator Feldman, are you going to show your face?
Yes, in a second. I will in a second. But I'm here. I'm a member of this very prestigious Oversight Committee, joining my two colleagues from the legislature. Thank you.
Okay.
Shout out, Delegate Valderrama. Appreciate it.
Okay. All right. Well, and from here, we are going to let staff introduce the bills that are on the agenda and explain them, and then we'll take turns whether the defense goes first or we'll switch between the defense and the offense and all that. Okay.
Very good. The first bill on the agenda today is Senate Bill 10, which will be heard tomorrow in the Senate Finance Committee. Senate Bill 10, Workers' Compensation COVID-19 Occupational Disease Presumption. The bill is an emergency bill and establishes an occupational disease presumption for a first responder or public safety employee or a healthcare worker as defined under the bill who tests positive or is diagnosed with COVID-19. The bill is to be applied retroactively and must be applied and interpreted to affect workers' compensation claims filed on or after March 1st, 2020, and the bill terminates July 31st, 2023.
Okay, Carmine and your group, do you want to start out?
Yes, ma'am. Thank you, Senator. So similar to last year, Chesapeake and IWIF will be opposing this bill. As we testified last year, the vast majority of the COVID cases that we have had filed, we have accepted or the commission has approved. Out of the 152 claims, we've accepted 111. The commission has denied only 10, and there are some others that have been withdrawn or in various stages. As you can tell, the vast majority have been accepted. We do not feel there is a need for a presumption based on that. And secondly, and a significant change since last year, with the advent of the Omicron variant, even the Supreme Court recently has said that COVID has now become a condition of life. And once they made that statement, it is no longer an occupational hazard because it's transcending everyone's occupation. So we'll be submitting some of that documentation as well. But our testimony, Senator Feldman, Delegate Valderrama, will track last year's for similar reasons. We're opposing the bill.
I have a quick question, and if I missed it, I apologize. What was it all occupations? Did I miss it? I know he used to be former.
Delegate Valderrama, it's police, fire, public safety, correctional, with the addition of healthcare. So healthcare, it doesn't add teachers the way the one last year did, or essential employees. They're the two that have been taken out, it seems like, but healthcare has been added to the public safety.
Okay.
But we've had 125, you said?
Well, these are just my claims, Senator Klossmeyer.
Okay. Oh, okay. Well, maybe Carl can. Okay. But that's still. Okay. Does anyone else on your panel want to speak, or is that?
I'd given Nathan some names, but they all may be before the commission, Mr. Daly and Ms. Murray.
Oh, Rudy's there.
But Rudy's there to speak if he so chooses.
You have anything to say, Rudy?
I know better.
Okay.
No one presented it better than Carmine.
Okay.
This is Ron Travers with Baltimore City. I echo Carmine's comments. What also bothers us is the vaccination aspect. What we found with the city is a very significant portion of our public safety employees have refused to be vaccinated, thus potentially increasing the exposure for any kind of damages or injuries for medical care and treatment that they may be exposed to. With that as a factor, I have a hard time, we have a hard time accepting any type of presumption for individuals that they're really not even doing what they need to do to protect themselves from where we're sitting.
Okay, thank you. Jim, then.
Which one?
Lanier or McAllister?
I'll just go. So
Okay.
if you look, I'll do some referring to the fiscal note, because as Mr. D'Alessandro said, he can only speak for one agency, like just for Chesapeake and IWIF. But there's over 1,000 first reports of injury, employers' first reports of injuries that were filed for COVID. So not every first report of injury from an employer turns into a claim, but that gives you an idea how many employers or insurers filed indicating COVID was a disease that was at least claimed by an employee at some point in the last year and a half, 2 years or so. But I think Mr. D'Alessandro actually brings up the exact reason why a presumption is needed. It is now, COVID is here, it's here to stay. This bill is specifically designed to protect just the first responders, just like cancers, just like heart disease, just like the other diseases of life that we all have to worry about, but that are distinctly concerning those first responders who have to have contact with the public that exposes them to things that they would not otherwise necessarily be exposed to. With Mr. Travers, he's getting into the benefits part of it, which I think is another reason why the presumption isn't necessarily bad, because more people are getting vaccinated, more people have immunities. Therefore, the risk of the money aspect of it, not to the compensability, not to is it a compensable claim, but the value of the claim itself has now gone down significantly because people aren't being as impacted as greatly. So the cost value to the employer insurer is lower. So I applaud Chesapeake for their numbers, but they are not the only insurer. And this is exactly why the presumption is needed to protect these diseases of life. And we also have the sunset provision, so we can come back, and if in a couple of years COVID is now just hopefully more like the flu, then we can let the entire statute, sunset out, and hopefully, I think we all can hope that that's the case. So that's why we are in support of the presumption bill, as we were last year, with a little bit of a change due to circumstances, but we are hoping to protect our first responders. Thank you.
Jim McAllister, do you have anything to say?
Yes, certainly. It's important to understand what a presumption is and what it isn't. A presumption is when I say, hey, let's go out to dinner at Mick O'Shea's across the street from my office, and somebody says, why not? Okay, well, that's what a presumption does. It shifts the burden of disproving something to somebody else. So what we're saying to these people who place their lives in harm's way, who expose themselves oftentimes prior to a vaccine even being available, to a disease so that our relatives would be treated in hospitals, so that the laws would be enforced. They didn't have any choice. Well, their choice was to say, I'm walking off the job. I'm not going to do it. So if they got sick, the only thing a presumption does is it shifts to the insurance company the burden to say, why not? How do they say why not? They get a hold of your client's bank records through subpoena. They find out that your client, flew to a truck convoy protest in Canada and hung out unmasked with anti-vaxxers or something. They get this information and they present it. So this is not a completely disarming game over situation. It merely says, look, if you were contracted this disease in the course of your employment and you're able to show a positive COVID test and that you did this work. And keep in mind, with COVID, you get a 14-day look back. So during those 14 days, where were you, what you were doing? And if you weren't doing anything that posed you at risk, then I think we owe it to these people to say, let's take care of you because you got sick. And let's not ask the taxpayers to pick that bill up. Let's not ask health insurers to pick that bill up. Let's not ask disability policies to pay for those losses. These people got sick on the job. And as long as they can prove that they were working and they got sick during that 14-day period, then I think we owe it to them to say, why not? Instead of you have to prove it. And if you can't, you lose. Thank you.
Okay, thank you. Any other comments?
This is Rudy Rhodes. As far as I'm concerned, the two things that the claimants' attorneys have generously admitted is that it's a disease of life and it's a health insurance matter. And that's why workers' compensation is not covering the flu and this more serious virus unless there's an employment-related cause. And that is what separates all those claims that are accepted from the few that are contested. And then the commission makes that adjudication like they would if it was any kind of serious disease like this, that the claimant is working, but not caused by work. And that's really the issue. And that's why it's worked so well in Maryland for the last going on 3 years. Thank you all.
Okay. Anybody else? All right, Delegate Valderrama, take her away.
Well, I had a question.
I believe there was a question.
Mr. Como.
Oh, I didn't see his hand.
I would just ask the two Jims, do you guys have an example of a first responder having a claim for COVID denied by the commission?
I will say that our firm took all COVID cases pro bono. So we were very choosy in the ones that we did take. I had some that were initially contested, but to be frank, they were eventually accepted. Most of them were IWIF cases. I had a correctional officer. I had an emergency room doctor whose COVID case was contested initially, eventually was accepted. So to be fair, I personally didn't have any, but I didn't have very many to begin with.
I've got 3 right now that are set for hearings that are healthcare workers who worked with respiratory patients. And one of those patients actually died of COVID. And, you know, this social worker that I'm representing, her employer said, when you go in the room with this person, don't wear a mask because it's bad for their mental state. So she got COVID. Everybody else that was in a staff meeting immediately after that exposure with the patient got COVID. And yes, they're denying the claim.
My question was, at this point, had the commission, to your guys' knowledge, denied any claims for a first responder? And it sounds like the answer is no.
Not me personally, but I can check with John Hall, who represents tons of first responders, and get you a question. Most of the first responders tend to be represented by certain groups of lawyers, and Mr. Lanier and I aren't part of that group. So,
well, to be fair, I'll refer back to last year's testimony where there was at least one municipality there was testimony on that was denying every COVID claim for any employee. That may, or I don't know that to be true anymore, but at least referring back to last year's testimony, yes, there were COVID claims being denied en masse by at least one municipality.
Well, that really wasn't the question, whether the claims were being initially, a lot of claims get initially denied by insurance companies or even by the city. But before I retired back in June, and this law would affect the commission, not the insurance companies, I found the commission to be very sympathetic to these claims. And I'm just not aware of any of them ever being denied. And I guess the question, what I'm getting at, is this a solution looking for a problem? I didn't really see it, guys, in being totally honest.
If that's the case, then that's why the sunset provision is there. If it turns out this is ultimately not necessary, then in 3 years it's gone anyway, or not even 3 years, 2 years.
But if no claims are being denied, is it necessary now?
Okay.
By the commission. By the commission.
Okay, Carl, do you have statistics on that? Do you have the data on that? I mean,
Senator, we do have some information.
Okay, information or whatever.
The information that we have is that there are some, I'm unaware of any first responder claims within the past year that have been denied. But I will double check on that.
Okay.
But they're very specific. And I know that to follow up on what Mr. Como said, that the commissioners take it really seriously, and they take a look at all of the situations. And sometimes, regardless of whether it's a first responder or just somebody who went to a basketball game as a vendor, those folks have very specific fact issues that are that sway which way it goes. We have a tendency to see this less as an issue of do you need a presumption of whether there's a disease or an accidental injury, as we do with, okay, we've got a problem here. What are the facts that call it? It's not like the cancer cases that we have in public safety. It's not like the heart disease cases in public safety. It's very fact specific.
All right, thank you. Any other questions? Comments?
Just to follow up real quick, while the chairman was talking, I checked our system. We have a first responder police officer COVID case that's currently set for hearing because it's contested. It's not mine, but it is in our office.
Okay. thank you. Okay, Delegate Valderrama, Tom,
I'm okay.
you're okay? Okay.
Yeah, thank you.
Valderrama, you want to take it over now?
So our next bill is Senate Bill 374 that I believe Senator Cheryl Kagan has submitted, which is the occupational disease presumption for 911 specialists.
Okay, so
Yes, this bill establishes a workers' compensation occupational disease presumption for 911 specialists as defined in the public safety article who are diagnosed with post-traumatic stress disorder by a licensed psychologist or psychiatrist.
I would assume that because this is a presumption, it would be the same arguments from both sides that we just heard on the prior legislation. Would that be accurate?
It would
Unless
be
there's
for
a-
me. It would be for me, Delegate.
Okay, I believe we may have heard this in our subcommittee because I'm looking at it. But I know this is not the first time Mr. Almond. Carl.
Yeah, thank you. I just wanted to let everyone know that we did a lot of research on this. We were asked by Senator Kagan's office specifically as to what the background was and if we had any cases. There are two parts of it. First of all, most of the folks who practice in comp know that more often than not, claims for PTSD or any psychological condition that emanate from an accidental injury come later in the claim. So it's not like it's filed as a psychological claim up front, typically. So it's harder to find those cases, but we spent a huge amount of time digging through all the files, and we were unable to find any cases at all where there was a claim for PTSD for 9/11 dispatchers or operators. We did have a few 9/11 cases, but they tended to be accidental injury cases. And so anyway, we just by way of information, we did not find a single case where there was any claim, regardless of whether it was accepted or denied, for PTSD or psychological condition for 9/11 operators.
Carl, do you know if any other states have that?
I am unaware of any other state that has a presumption for 9/11 dispatchers for this injury or occupational disease.
Carmine, you had mentioned something regarding legislation at one point. Can you just, so I can, 'cause I believe this is coming up again in our subcommittee.
For 911, I know that when I testified before Economic Matters, Delegate Valderrama, we went back 5 years, scrubbed our book. We currently have 339 cases active with PTSD in the description or in the medicals being paid. So what I testified to in ECM was that we did not feel a presumption was necessary as Maryland has recognized this condition through case law. So some states might have legislation because the conditions weren't recognized, but Maryland in 2 cases, Means versus Baltimore County, which I'll go through tomorrow if the Senate Finance wants, and then Belcher versus T. Rowe Price, the appellate courts of Maryland have specifically held that in a workers' compensation claim, post-traumatic stress is a viable condition. So my testimony was there was no need for legislation because our courts have already recognized this. And as you can tell, we have, so I said 339 claims. Those claims average incurred about $31,000 a claim. So we have spent significant sums on this condition.
I didn't realize it was a issue, but that's a whole nother aspect of it. Okay. Are there any other opinions? Okay, none. I'm going to move on to the next. Oh, Kathy, it's your bill.
I'm sorry, Ms. Delegate, can I go back for a second to
yes.
answer some of the questions? For those who may not be completely aware, this bill kind of comes from the 4-year study with 911 specialists that Senator Kagan and Delegate Hill kind of chaired the committee. the third year of their study focused on workers' compensation. It is a rather exhaustive report that I believe everyone has access to. I have a copy of it. To follow up on what the chairman said, there's a study that was done by University of Maryland Law School that's included in that report that answers a lot of the questions. For example, there are 2 states that have similar type bills, and that's in the Oregon and Colorado have PTSD occupational disease language in their statutes. So other states are addressing this. Not necessarily on par completely with how Maryland is trying to deal with it, but there are, I don't pretend to be a lawyer practicing in either one of those states, but that bill comes from that report. And a lot of the questions that this subcommittee may have are answered rather thoroughly in the 911 specialist report that was released. I think it was in December of 2021. So I would defer a lot of the questions to the material that was provided by the senator and the delegate.
Thank you, Jim.
Yeah.
Kathy, it's your bill. That's
okay.
whatever.
The next bill, I am going to defer to council. Nathan.
Next one on the list is Senate Bill 433. That's workers' compensation claims fees for legal services. Senator Klausmeyer's bill would authorize the Workers' Comp Commission to order a fee of up to $2,000 be paid for legal services rendered on behalf of a covered employee if no compensation other than a medical benefit is payable to the covered employee. The commission may order the fee to be paid by the covered employee, the employer or its insurer, a self-insured employer, or UEF. And the bill is to be applied prospectively.
Actually, I realize that's our cross file. I put that in as well.
How about, I just want to say, Deborah Phaedra Smith has joined us. Just want to say hi. You'd like to introduce yourself? You're on mute.
Can you hear me?
Yeah.
Hi, Deborah Phaedra Smith. I'm a plaintiff's attorney, but I'm a public member at large.
Okay, thank you. And Julie?
Hi, this is Julie Murray. I'm sorry, I'm jumping on in between commission hearings. I'm with Maryland Defense Council.
Okay. Anybody else?
I'm a co-chair.
Introduced? Okay. Now, does anybody have any questions about the past bill that Nathan just, the fees? Jim? Jim?
Yes, ma'am. So this bill's been up for a couple of years now. It's essentially trying to solve a very specific problem, which is those people, those claimants who are, mostly either unrepresented totally or they don't have a lawyer for whatever reason, who are trying to hire an attorney when indemnity is no longer payable. So at this point, unless we want to go into debt to represent these people because we can't get fees and we can't even get our expenses back, this bill is designed to give the commission discretion to allow us to either for the commissioners to approve a fee directly from a claimant, or if you have a destitute claimant in those rare occasions where then the commission would have the discretion to order some or other payor, an employer, insurer, self-insured employer, or the UEF, uninsured employers fund, to pay the fee up to $2,000. They can award $0, they can award $2,000, and it can come from the claimant if the claimant has the means. That we would have a normal legal service agreement contract we have with pretty much any other, personal injury type of claim. And it's attempting to kind of level the playing field when you have an unrepresented claimant who does not have the legal background, doesn't understand how the procedures of the commission work, and doesn't necessarily understand what they need to prove their case, because the burden is always on the claimant, to then be able to come back and argue that they're entitled to medical care, because these are the type of people who have long-term claims and they don't have an attorney for whatever reason. Because if they were coming back 5 or 10 years later, those are usually the people that have much more significant injuries. And instead of potentially having the at fault, the insurer be on the hook for the risk of which, because it's a workers' comp claim, then those people then use their health insurance, they use Medicare, they use Medicaid, and it becomes a burden on the claimant or on the taxpayer to pay for what medical care should potentially be under the claim to begin with. So that's ultimately the problem. What we're looking to solve here is to help unrepresented people come to the commission and get the medical benefits that they're entitled to with discretion and oversight of the commission as they have on all fees.
Anybody else have anything to add?
Yes, Senator Jim McAllister.
Okay, Jim.
So there are basically three situations that this is designed to apply to. The first is if the claimant has entered into a settlement where they've settled out their right to indemnity benefits, meaning in exchange for a lump sum of money, they've decided to leave their medical claims open, but settle out their right to get future compensation. The second is there's a cap in the regulations at the Workers' Comp Commission on how much an attorney can be paid for handling the entire claim. Once that cap is exceeded, no future attorney's fees can be paid to a lawyer who takes up the claimant's cause, except in exceptional circumstances. And the third is you have to come back within 5 years of the last payment of compensation and reopen and ask for more money, or the right to money dies. It's a statute of limitations built into the comp law. So we have this large body of injured workers out there who usually pretty far down the road are very seriously injured, need a surgery, need medical treatment, and they can't get a lawyer. So what does this bill do? It does two things. Number one, it gives commission control over the fee. The fee is up to $2,000. It doesn't have to be $2,000. The commission can make it whatever the commission wants to make it. Number two, it says may. Doesn't say shall, doesn't say a commissioner is required. And an amendment we would agree to is only if the claimant's lawyer wins. So if someone comes to me and has a medical only issue and I lose at the commission, then I shouldn't have the right to be paid under this bill. But if I win, now here's where the real rub is. Under the current law, you can get an attorney's fee from the insurance company if the insurance company has litigated that issue in bad faith. 99% of these disputed medical claims are not litigated in bad faith. The insurance company has your client seen by their doctor who says your client's fine and should be trying out for the Olympics. And that happens in lots of cases, okay? But it's their right to get a medical, and it's their right to dispute the request for treatment. And that's not fraud, okay? So that's not sanctionable conduct. So what happens to these 99% of the people that they deny medical care to that aren't the victims of fraud or overreach by the insurance company, but it's the insurance company raising what they consider to be a good faith defense. If the claimant can't get a lawyer, you know what the claimant does? They don't go into court to the commission unrepresented. They put it through health insurance, they put it through medical assistance, and they put it through Medicare. And if you're an insurance company, and there are well-intentioned people on both sides of this, if you're an insurance and you can get away with denying a claim, why wouldn't you? Why wouldn't you raise a defense to a medical claim? Because odds are the claimant's not going to come back, and the claimant's not going to say, gee, I'm going to come in here like Don Quixote and joust with a windmill, unrepresented with an attorney on the other side. And it burdens the commissioners as well, because they've got some, elderly individual with a shopping bag full of medical bills trying to sort things out at a commission hearing, unrepresented, with an attorney raising objections. And the commissioners have to apply the rules. Just because you're not represented doesn't mean the rules don't apply. So we think this levels the playing field. It says may, it doesn't say shall. And if injured workers get the medical treatment that the legislature wants them to get, and we win, okay, then what's wrong with that?
Okay. Anyone else like to add?
Yes, ma'am. So just, I guess for a preview for tomorrow.
Okay.
We did testify. This has already been heard before Delegate Valderrama and ECM. Between Chesapeake and IWIF, we have about 30% of the workload that's out there going to the commission. Between those two agencies, we're averaging about 6 of these cases a year where there's actually an unrepresented claimant seeking medical treatment. So If we have 30% of the market out there and there's only 6 of these situations coming up a year, I don't think that there is a vast problem. Secondly, as we've said multiple times, the entire fee structure is in COMAR. This would be a one-off where a little piece of the fee structure is taken from COMAR and moved to the statute. So we would obviously oppose splitting that up. And as you know, the commission, as you recall last year, Senator Klausmeier, you had asked the commission to look at the regs. We had talked about perhaps working on them. The commission actually increased the fee for settlements by 5%. So there was one issue where in the last year, the commission has increased the fee for attorneys. The commission has now put in, as Mr. McAllister said, the clause where they can assign a fee even beyond 2,000 if they feel that in that last example, what Mr. McAllister explained, that's when you get hit with a fee. If I'm just coming in there because I know that someone's unrepresented, I'm going to get hit with one of those fees because I've frivolously taken that case. I also believe that, you know, I would, and I've told this to Mr. McAllister, and I think you as well, Senator Klausmeier, we would support an increase in the cap in COMAR. But obviously, I support that at Chairman Allman's timetable. So if there's a reason they're looking at it later or not now, I support their timetable. But I would certainly support the trial bar's efforts to increase that cap in COMAR.
And Senator Klausmeier, you and I and Mr. Alessandro did meet and had some discussions, because one of the problems that has generated this bill is that the caps on attorneys' fees are we believe are restrictively low. And, you know, we would support some sort of compromise where, you know, the fees are increased, the caps on the fees are increased. But unfortunately, you're talking about games being played on 2 separate playing fields. One is a regulatory change at the commission, and this is a statute. So, and I'm glad the chairman's on this call. I just don't know how to make that happen or if that can happen. So.
Mr. Chairman.
In response to the legislation last year and the discussions that we've had over the past few years, the commission looked at very closely at changing regulations on the fees for the attorneys. And we were really close to implementing it. And then all of a sudden, the average weekly wage on which the fees are based increased by 30%. We went from just about $1,000 a week state average weekly wage to over $1,300 a week. And we're really concerned about sort of a roller coaster effect on the fees. So our hope is to take a look at this a little bit later this year and see if in fact there's a modulation in the average weekly wage. And I know that Mr. Benedict, who's on the committee from NCCI, has had some significant questions from his actuaries on this. We want to see how this plays out before we implement a regulatory change that would address the question. But there is a significant increase this year in the baseline on how those attorneys' fees are calculated.
But Mr. Chairman, can I ask a question? That would just be on claims for injuries and occupational diseases that occur in 2022, right?
That is true. That is true. But it's not inconsequential, and we want to see how it all figures out. We do not want a situation where this year we have, we have an increase, a large increase in what the fees can be, and then next year have a huge drop, and everybody being upset because there's a big drop in what the fees, the potential fees are.
So, Carl, what is a good timeline? Do you have like a time when you
I believe that the state average weekly wage, which is based on the prior year, will come out in probably July, maybe August. And at that point in time, we can have some serious analysis of where it's going and where it looks like it's going. It may be that because of the COVID situation that the average weekly wage drops back down. And if that's the case, then we can go ahead and implement those changes to the average, to the attorney's fees that we intended. If it stays the same, then we may want to moderate it a little bit so there's not such a large increase all at once.
Yeah, well, I'm just thinking about all of the places like McDonald's and everywhere. It seems like the money has gone up, as far as how much they're getting an hour. So
that's certainly part of it, Senator.
Yeah.
But the thing we found from speaking with the people at the Department of Labor here in Maryland is that the state average weekly wage increased a lot because during COVID, people who were in lower paying positions, hospitality and cleaning and those jobs were eliminated, or they weren't making any money at all during that time. So all of a sudden you eliminate a large group of people who were making a lot less money than other folks, say white collar jobs and other positions. So it kind of skewed that average weekly wage.
Okay.
Now that it's getting better and we have a lot of those folks back at work, we may see a change. We just don't know yet, and that's what we're waiting to see.
Senator, if I can.
Okay, yeah, Deborah.
I just want to clarify. I don't think I'm understanding. It sounds like we're mixing apples and oranges. I mean, earlier this year, there's a regulation of some sort that doesn't allow for claimants' attorneys to withdraw from cases and without permission, so to speak, like they don't trust the attorneys, and which I think is an overstep of regulation. But in any event, I thought that the reason for that is because you're finding people showing up without attorneys to help them with their medical bills. So I think that there's two different issues here. We're not really talking about raising attorneys' fees. I think we're talking about addressing the medical issue. And I don't really think that, charging fees of a client, which I've never done hourly like that in my life, is going to help. If they don't have the money for the bills, they're not going to have the money to pay an attorney in reality. But I think that another avenue has to be thought of. Maybe this can be studied as to, Carmen says there's only a few percent, of his cases, but if that's true, then why the urgency to request attorneys not to pull out and leave the client stranded after an indemnity award, which they shouldn't do anyway. But the problem why they're doing it is because they don't want to be on the hook for another 10 years and not being paid. Just to give you the background, Senator. So it is an issue that we have to look at as a community. I don't think this bill expressly does it, but it's a completely different issue than what you're talking about in terms of raising attorney's fees. It's really the allocation of who's going to be holding the bag for these bills. And that's my only question.
Any remarks for that?
If I may, so I think we're a little far afield from this bill, but one of the things about the modulation the chairman has mentioned, and one of the things Ms. Fraser-Smith has mentioned, can be solved. I mean, this is a slightly different tangential issue, but eliminate the attorney's fee tiers, because then you have attorneys willing to stay on their files and not abandon these poor. I mean, my firm has a policy. Once they're in the door, they're ours. We don't ever get rid of clients unless we don't have any other choice. But other firms have different business models.
I agree with that. I agree with that.
But other attorneys have different business models. But one way to keep people involved is to potentially eliminate the tiering system of attorney's fees for claimants. And then they'll have a business reason to stay on the file, and they won't have to look for someone like me or Ms. Fraser-Smith or Mr. McAllister, because their other attorney will stay with them. Again, that's a slightly different issue than what the bill is about, but that's part of the overarching concern about keeping quality attorneys on the claimant's file to get them representation.
Okay.
Yeah, and I think it's really much more regulatory to try to tell an attorney they can't withdraw without permission when obviously there are two types of attorneys, as Mr. Lanier just mentioned. And that doesn't really, to punish the good people over the people who are committing the issues is wrong. So I really feel that it needs to be addressed in a totally different way that's a little more transparent and is not so much trying to fix it with a little regulation of saying, well, we'll approve whether you get out or not. I don't think that's the right way to go.
But isn't that the way that the circuit court and the district courts operate? Don't they require that withdrawal of appearance for an attorney be approved by the court?
Not necessarily, and not specifically for one issue about about medical bills. It all depends. I only do civil practice, but usually if there's a stipulation, attorneys leave right and left. If an attorney left a firm and decides to take the cases and withdraws or whatever, it happens all the time. I just think that's a little too narrow and a little too, what's the word I want to use? Regulatory, I guess, taking away independence of attorneys over one specific issue you're trying to solve, and that's not the way to solve it.
Okay. Any other questions or comments? I think we're going to have to work on this one a little bit, get everybody in the room. So, but for now, okay. Delegate Valderrama.
Erica, the last bill is House Bill 614.
The next bill is House Bill 614, Workers' Compensation and Medical Cannabis Compensation and Benefits. This bill has been withdrawn by the sponsor.
Which would be me. This was a bill that came before us this year and last year. Last year was cross-filed by the famous Senator Brian Feldman, who, due to limits on legislation submission on the Senate side, could not put it in this year. But I wanted to at least resubmit for the subcommittee. The chairman, the current chairman, the new chairman already had his idea of where it was going, and I respectfully requested that it go to subcommittee, which we took up last week, just so we could have healthy debate. And I believe Carmine was on there with us. And I want to say that I misspoke during that meeting. The question was asked by the current subcommittee chair if the client that had brought this legislation to both Senator Feldman and I was being reimbursed. And in fact, because I was looking at so many notes and dealing with others, I responded incorrectly. He was not being reimbursed. So I want to just retract that, even though no one on this meeting was on that meeting except for Carmine. But I definitely think it's going to be a bill that I personally will be bringing forth regularly. It is my understanding. Oh, it's also Mr. D'Alessandro from Just Speak also had said that whether it was in the meeting or not, but I know in our personal meetings that it was not. And if I'm misspeaking, Mr. D'Alessandro, please correct me, that it did not appear to be a huge deal, that's layman's terms, with regards to this, because I definitely don't believe that someone in this particular constituent's manner should be paying for his medical cannabis when it's sorely doing the trick. He was, making a long story short, he had a severe addiction to opioids, and clearly that wasn't doing him any service. So with that said, there was a lot of conversation in the meeting last week about other details of this legislation, but I feel like this is definitely an issue that should be discussed in all sincerity, in all seriousness, and not just me submitting this bill yearly. So I would really, if it is this joint committee's will, I'm open to conversations from any one of you, in addition to Mr. D'Alessandro. So with that said, I respectfully withdrew it because I did not want it to have a down vote on the record. I see Senator Feldman has.
Yeah, I understand. I get the bill in the House was withdrawn, but I did introduce the bill last year, and I do want to sort of get a little sense of things. So last year, Chesapeake, unlike the prior years, actually took a neutral position, did not oppose. Some of the national carriers, because we're talking about federal law implications, were opposed. In the meantime, we're sitting with 150 1,000 medical cannabis patients right now in the state of Maryland. So this issue is not going away. I guess the two questions I'd have in this, I mean, I know I've talked to Chair Allman about this. So right now in the commission, do we have any pending cases? I know that at one time, I think whether it was Commissioner Quinn or whatever, there wasn't even consistency amongst the commissioners about this topic, which I think is, you know, a little bit unusual, or what, depending on what commissioner you get. And I know there were some appeals from at least one or two of those decisions. So I guess the first question is, you know, are there any pending cases seeking reimbursement currently in either in the commission or on appeal? And secondly, the national landscape, at least, we have 38 states now with medical cannabis programs. And I think at least as of last year, when we had the bills in 2021, there was at least 5 states did weigh in, whether it was the commission, the courts. I'm not sure if there were legislative action. I can't recall, maybe New Mexico, I don't remember, but just give us something. The bills were withdrawn, you know, the bill was withdrawn, I get that, but I don't think the subject is going away. So tell me who can, like what's happening nationally. Is there anything here in Maryland pending? I think that would be helpful, or anybody else wants to weigh in. I see at least somebody on the chat on behalf of the business owners would like to weigh in.
Yes, Mary Ann?
Sure.
Hi, good afternoon. I'm Mary Ann Rushling, and I'm a representative on this committee for business owners. I think this bill would pose, even though it's been withdrawn now, going into the future, we would oppose this bill because it places an undue burden on the employers. I was one of the people that testified originally, probably 2 decades ago, on this bill regarding workplace injuries and people that are impaired. When you have a situation where an employee is impaired by drugs or alcohol, was the original bill, it was, we had a horrendous truck crash with my prior employer, and the employee was under the influence of drugs. And it caused a fatality, and it was something where we then had to pay. This is prior to the legislation that was proposed and adopted by the state of Maryland for workers' comp benefits. We had to pay workers' comp benefits in that case. I think that this bill, proposing that the employers, in addition to paying workers' comp benefits, in some cases it says, would have to pay for the medical cannabis for these employees. I understand if it's restricted by federal or state law, the employer would not have to, but that's not in every case. So when you have these situations where employees, specifically people in safety sensitive positions, are required to do drug testing, and they come up and test positive, either post-accident or during a random, the employers have to deal with that. Now, this bill or this type of legislation is saying that we should not only have to pay for the medical cannabis in non-safety sensitive or non-regulated positions, but we would also have to pay workers' comp benefits, which is in conflict with the federal regulations at this point. So I think that this would be.
I actually don't think that's the way, at least the bills last year were not. First of all, it was a reimbursement. Mary Ann, can I just, I don't want to spend too much time on the bills we withdraw, but I'm hearing you, but I'm still confused by this whole subject, because the gentleman that Delegate Valderrama was talking about is opioid addicted. Okay, so opioids.
Was that caused by the employer? Was his
no,
then why should
right, but I mean, if you okay, but let's just sort of basic state-sanctioned legal cannabis business we have in Maryland, like you have, this is about pain relief, work-related pain relief, and you don't want to get addicted to pills. The idea that you go to an alternative, that somehow that's a whole different subject area. People can show up addicted, as you just point out. I mean, I'm not sure. I've always had, the last couple of years, some trouble here. If somebody doesn't want to get addicted to opioids and instead gets pain relief, with something that the state has passed that's legal in our state, that they can't get reimbursement from the carrier for that. So it's designed for reimbursement, not a direct payment from the employer. The testing issues, I'm not sure, I'd look for some help here from Carl, but I'm hearing you, but I'm not sure how that fits necessarily within kind of the broader policy conversation.
Well,
I'll let Mr. Almond, and then I'll weigh in again briefly.
where'd he go?
I'm here. Do you want me to speak now?
Yes.
Yeah, I mean, I don't want to dwell too much because the bills aren't
Yeah,
ending this year.
No.
But I do think it's a subject that's likely to come back. So I think it's worth at least a few minutes just chatting a bit about the subject.
And I agree, but I think, and I'm going to let Carl talk, but I think it's something that if we're real serious about it, we take it up in the fall.
Yeah, no, that's fair. Why don't you let Carl, and then I don't have anything more to say. I just want to put it out there.
Okay, thanks.
Let me address the big question that Senator Feldman raised, which is what we monitor really closely. And that is, how often does this come up? And I was quite frankly shocked at how infrequently it happens. We looked at the last 2 years, and in the first of those 2 years, we only had 6 cases where there was a dispute over the payment of medical cannabis. And it was split. The decisions came down split, 3 yes and 3 no. And for various reasons, quite frankly, it wasn't that there was a commissioner who says there's no way I'm going to approve it. Sometimes it's just a matter that the question is that the best modality in that particular case? Regardless, 6 cases in 1 year, and then we had 8 cases last year. And in those 8 cases, 6 of them were approved and 2 were denied. We're just not seeing any volume on this. We hear thousands of cases a year, and where this is a dispute, it's just not showing up very much. And frequently, we've come to a way that if there's an agreement that the employer or the insurer is going to pay for it, then we can craft language in the order that gives some wiggle room to protect the employer regarding any federal potential penalty for it, in light of, we're not mentioning the fact that it may be medical cannabis. There's a way to craft the language that gets the injured worker reimbursed for the payment of it without implicating an employer approving medical cannabis in and of itself. But the real thing is that we're just not seeing that many of these cases.
If I may, based on what you just said, Commissioner, Mr. Almond, is that while you're not seeing that many cases, would that prevent us from having this statute? I mean, I believe, I know they don't happen as often, but and if I misinterpreted what you said, what I understood was that if we were to pursue this, then there would be certain language, for what Miss Marianne was stating, as far as employers are concerned, because I personally don't think, because there's not that many instances, that this should not exist. But again, that's just my 2 cents.
No, I certainly have no opinion on whether there should be the statute, especially based on how many. The question is this something that we're having a big problem with that we need to address? And in all candor, I don't see where we're having a real dispute over the payment reimbursement for medical cannabis and workers' comp cases.
Okay, it looks like Mary Ann has a question up there in the corner.
Just one more comment. I really think that this would be the camel's nose under the tent, and it does not help the employers whatsoever. And I realize that it's for the employee's benefit, but it really puts the employer in a pickle if you have somebody in a safety sensitive position, such as a commercial driver or even just a delivery driver, the regular car services. If that person is impaired and they cause injury to someone else or death to someone else, then the employer is on the hook for the liability and the workers' comp in this situation. And you could also, we as employers could be hit with punitive damages because we had a person that was knowingly taken a banned substance, federally banned substance, and letting them operate in a commercial driver situation or a truck situation. And it could.
Can I just, we can move forward. I just want to say, there's nothing in any of the laws we've passed that precludes the employer from testing every darn day for that very thing. I'm not sure this idea of impairment in the workplace. Private sector employers are completely 100% entitled to do everything they need to do to make sure that doesn't happen, including testing somebody every morning before they go. And, so I'm not sure what that has to do with anything, but I'll drop it.
Okay, good. Well, I think there needs to be discussion because every year we have the bill and it just kind of falls flat, and maybe it's time we really take a good serious look at it. So, and I'm willing to do that with the commission. So any other comments for today? Delegate Valderrama, do you want to?
No, that was the last bill was really the one I wanted to talk about. So thank you. Thank you, Senator Feldman.
Okay, Nathan or Erica, do you have anything?
There is one more bill on the agenda.
Oh, there's one more bill.
Yeah, there's one more bill.
Oh.
House Bill 1164, Labor and Employment Workers Compensation Licensed Certified Social Worker Clinical. This bill authorizes a licensed certified social worker clinical, say that 5 times fast, to register for the Workers' Compensation Commission as a rehabilitation practitioner for purposes of providing rehab services under workers' comp law. To qualify for registration, a licensed certified social worker clinical must be certified by the State Board of Social Work Examiners. The bill also specifies that if a permanent impairment in a workers' compensation claim involves a behavioral or mental disorder, a licensed certified social worker clinical may perform an evaluation of the mental or behavioral portion of the permanent impairment as specified.
Can you say that just very quickly, 2 sentences, what it exactly does?
It allows licensed certified social worker clinicals to participate in the and give rehabilitation services for workers' compensation purposes.
Oh, okay.
We had that in subcommittee.
Any thoughts on that from anybody? This is something new.
Madam Senator, can I ask a question? Mr. McCurdy sent out his email saying the bill had been withdrawn. Is that incorrect?
House Bill 614, the medical cannabis bill, is the bill that you identified, Jim, as having been withdrawn. And
No, I'm just looking, it says House Bill 1164 has been withdrawn in addition to the cannabis bill. Is that just incorrect? This bill's still live?
What was that hearing?
Yes, House Bill 1164 has not been withdrawn.
Oh, okay.
That would be a typo based on the number of 1s, 6s, and 4s.
Yes, sir.
Bills.
So I just wanted to clarify. Thank you.
Okay, and is it just a House bill?
There's no cross file, it's just the House bill.
Okay.
And it was heard on 215, so it's already been heard in economic matters.
Yes, it was heard on March 1st in economic matters.
And
Hey, Madam
so,
Chair. Oh,
Delegate Valderrama, are you taking that up? And well,
I'm looking at my files as I speak.
now, will it be taken up in your subcommittee?
It's not on the agenda for subcommittee this coming Thursday.
Pardon me?
It will not be heard by subcommittee this coming Thursday.
Okay.
I also no longer chair that, so I'm.
No, that's why I made that mistake and asked you that. But we thought we were losing Delegate Valderrama as the co-chair, but
No, we weren't going to let that happen. We used all the political capital we had.
Yes.
That would not happen. So.
Yeah.
Hey, can I just one final back? I'm sorry, Madam Chair.
Wait a minute, does anybody have anything to say about that bill in particular? It kind of, for me,
There was one, just so as Delegate Valderrama knows, there was no one discussed the bill in opposition. There was only one individual that testified support. It was actually a kind of a difficult hearing, if you remember, Delegate Valderrama, to understand what the impetus of the bill was. We took no position, but that's where it is right now.
Okay. And Senator Feldman, did you want to?
Yeah, just one, I hate to harp on that prior bill. One final thing for Mary Ann. So there's nothing in current law that any private sector employer can have a 100% drug-free requirement. You can actually tell your workers that they are precluded and they would be fired if they have take medical cannabis. So there's nothing infringing upon the private sector employer to say that and then fire somebody if they actually, tested at any point positive for that. So I just felt like I have to throw that in the mix as well. Sorry.
Thank you.
Sorry, Madam
Thank you.
Chair. Apologize.
Thank you.
If there is
Okay.
a committee on this or a task force or something, I'd love to be part of that.
Okay. Sounds good. All right. Well, no other comments. All right. I just want to thank everyone for coming on. And tomorrow we will be having, am I right, Nathan, tomorrow's Workers' Comp Day in Senate Finance. So we'll see many of you in person if you feel like coming.
So not fair. You guys are all in person.
Yes. Okay.
Wait, can I just tell the group that tonight, after 2 years, not only will we be in person, we will have no masks in the Senate chamber tonight since March of 2020. So this is a demarcation point for the state Senate of Maryland. And tonight is the night that happens. So I just feel like
We still have to wear ours in the chamber.
unlike the House, which still does Zoom hearings and everybody's masked up and,
We don't have to wear it in the House building anymore, but we have to
Oh.
wear it on the floor.
We do not.
Well, I only
We're
bring
always
that up.
ahead of you guys.
The
We're always
reason
ahead of you.
the reason I'm bringing it up is tomorrow, if you come to testify in the Finance Committee, you will not be required to have a mask. That was really my main point.
You guys are
Excellent.
really.
All right.
All right. Thank
Well,
you,
thank you all
everyone.